Welcome to Third Fridays, the monthly legal talk show from Lois LLC featuring attorney Christian Cison. This is the original forum in which real attorneys discuss workers' compensation issues, share their opinions, and engage in colorful conversations. This show showcases diverse perspectives of attorneys handling workers' comp cases, including case law trends, practical litigation strategies, and hot topics. Here's your host, Christian Cison.
Hi, everybody, and this is Christian Cison welcoming you back to the Third Fridays podcast. It's June of 2022. We're right into the thick of summer and enjoying our time as the weather gets nicer. We have a great show for you today. We're going to start with an attorney conversation about World Trade Center claims and then transfer to a segment with the paralegals called the Paralegal Minute, where we're going to talk about a case involving pet snakes and working for companies that you might not be telling the insurance company or your own attorneys, which will be kind of fun. That will be with Uma Mistry and Melissa Gannon. But first on the show, I have my fellow partner here at Lois Law Firm and a very, very, very significantly invested man in World Trade Center claims based on his experience and success defending those cases. Tim Kane, welcome to the show.
Thank you.
Now, when I think of World Trade Center claim, I immediately think, aren't we in the year 2022? I know it was a very devastating event for us that we're still grieving, but why are we litigating World Trade Center claims 21 years later?
Well, the reality is, if we're talking about new claims, substantially all of them are for latent diseases, so respiratory illnesses or cancer, things like that, things that people maybe weren't diagnosed with until just recently, and maybe they go out of work or they just go see a doctor and get diagnosed and they file their WTC-12, they file their C3, and here we are.
Okay, yeah, that makes sense, right? They're not filing an orthopedic ankle injury from a slip and fall at the World Trade Center 21 years ago.
Correct.
Or maybe they are, but they're not getting sent to us to litigate because those are very clearly claims that are late in terms of timely filing, right?
Yeah, I mean, substantially all of them, maybe all of the ones we're seeing now are for occupational illnesses, breathing things, stuff like that, or psychological claims as well, but usually not orthopedic injuries at this stage.
That, in theory, wouldn't have a direct or maybe sudden manifestation in 2001 or 2002. It's 20 years of the fact I now have lung cancer or emphysema or some kind of respiratory illness,
right?
Because,
asthma.
Yeah, it hasn't been discovered. So if we can take our clients kind of closer back from the cliff when they realize that it's 21 years later and we can still be hit with exposure, we'll just walk them back. It's okay. Come back to the safe space. Put yourself, maybe in their shoes, and you get a claim form. What is your first, second, third step for investigating this type of thing and making sure that no one's trying to pull a fast one on us?
So there are a few different prongs that you definitely want to look at basically every single time. One of them, if it's possible, is to speak to the insured. And that's often difficult because a lot of times, most times maybe, that insurance carrier no longer insures that employer. You're talking about a contract that existed 20 years ago. So if it's possible, speak to the insured, find out whether that claimant was an employee of that insured, find out what kind of work they were doing, that kind of thing. Again, that's going to be a tough one in a lot of instances. You might not have anybody left at the insured who remembers the person. The company might not even be in business anymore. There might not be a good relationship with the insurance carrier, but if it's possible, that's a huge one. Being that that's often not possible, you've also got things like the union records, right? Article 8A claims, World Trade Center claims, have a specific period for when the exposure occurred. It's 9/11/01 through 9/12/02. So you want to look and see, was my insured the last exposure within that period? Right. So the union records are hugely important in Article 8A claims. If they haven't been filed at the time of the C3 having been filed, or if they haven't been filed by the time you go to trial, that's definitely something you want to ask for, production of the union records. There's also the WTC-12 and the C3 themselves. Those are the claim forms. You want to see what's being alleged. Were they doing Article 8A work, which is rescue, cleanup, and recovery? Let's say the person was, I don't know, a hairdresser or a security guard or who knows, anything where they were doing their normal job activity, and maybe they were in the Article 8A zone of danger, which is defined by statute. It's a specific area down in Lower Manhattan and certain other specific areas that had to do with the cleanup. But if they were in that area but just doing their regular job, you have a good argument that they were doing routine work and their claim is not subject to Article 8A.
It wouldn't be recovery, it wouldn't be rescue, it wouldn't be cleanup. The hairdresser, the security guard would be performing hairdressing work or security guard work, and that wouldn't be classified as or covered by Article 8.
Exactly.
So I guess, that's what you're also trying to decide with the employer. I think you're right, like with trying to determine the elementary employment relationship defense, but sometimes I look at that being more crucial because more often than not, the claimant probably knows he or she has to produce the union records to show that he had work during the relevant 366 days, right? But he or she also has to know that the work that he or she is doing within that time has to be covered under rescue, cleanup, and recovery, right? So you're not going to get a hairdresser claiming exposure under this article, right?
You'd be surprised at the number of claims that are filed by people who, realistically, what you see a lot are construction workers who were directly involved in the cleanup. And some of these other types of employment, like the security guard, there are people who were just down there and they weren't doing what we call Article 8A work, but they get filed often enough. And so this is an excellent defense to keep in mind. It definitely happens. But realistically, most of these claims are people who were directly involved. And so those union records can be very important because even if your insured was the last employer during the Article 8A period, maybe they weren't doing Article 8A work for your employer, right?
Oh, right. So maybe they did work that's covered by statute, but it's really the exposures associated with someone else.
Right. Maybe they were doing rescue, cleanup, and recovery in September and October of 2001, but by the time they worked for your client's insured in August and September of 2002, maybe they were just doing regular old construction.
Oh,
maybe they weren't engaging in rescue, cleanup, and recovery at that point. And there is some case law that says that economic recovery does not count as recovery pursuant to Article 8A.
Right. I was actually just going to bring like something like that up because recovery sounds like the catch-all, right? Like rescue, cleanup, and recovery. Like seems like a wide umbrella. Be like, oh yeah, the recovery of the nation or the state of New York, the city of New York, where we're all recovering from it. I was doing my part, right, to help out. So economic recovery, taking that out actually makes the umbrella a little bit more narrow because I could probably argue that anything in that zone of danger in that relevant time period was associated with economic recovery.
You could certainly make that argument. And again, that's where having an employer witness helps, or even the union records, if you're looking at where the job was located and what kind of job they had. Asbestos cleanup is a good example. If the person was clearly engaged in rescue, cleanup, and recovery, again, closer to the time of the disaster, and then they went back to their plain old asbestos removal job, and you cross-examine them and you say, oh, by the time I worked for that company at that time, I was just going back to the normal routine work of an asbestos removal. Yeah, then it's maybe not even economic recovery. At that point, it's just routine work. But point being, recovery under the statute, for better or for worse, refers specifically to the recovery of human remains.
Right. Okay. Then that actually takes another umbrella and makes it more narrow. Right. Human remains, and then gets it a little dark, and we understand that. And I think that there are some insurance companies and employers that do look at a situation like a 9/11 claimant, and really decide that this is a compensable claim. Somehow, though, when we're looking at even the asthmas and the cancers that aren't populated or aren't manifesting in 2001, 2002, is there any timely filing argument that we can make by investigating medical records before they actually file. Like maybe they might file today, but 2 or 3 years ago, they're getting scans for cancer. They're saying all this stuff. Is there any timely filing application or defense we can assert by investigating pre-existing medical records?
Yes, subject to the caveat that, Article 8A claims, the judge is actually required to pick the date of disablement most favorable to the claimant.
Right.
Most favorable. So if they kept working, even if they've been treating for a while, if they kept working until just recently, or if they're still working, timely filing is going to be a tough one. But again, if you can show that they weren't doing Article 8A work, and then it goes from being an Article 8A claim to just an accidental exposure, and then once they remove from the exposure, that's only 2 years. So it's no longer an occupational illness necessarily, kind of depending on what the medical reports say, and how long they kept working for, things like that. So it really does. Timely filing is definitely something you want to look at. It's definitely something you want to raise when you go in there. And a lot of it depends on how the illness is characterized, what type of work they were doing, when they stopped working, all those things.
Okay. And just to let everybody know, right, we're not just here to discuss theories, and we're not creating any kind of hypothetical for it. We're out on the battlegrounds litigating these cases, and Tim recently had a board panel decision that rescinded some findings that were adverse to our client. So how did you build those investigation tactics into creating an argument that worked for the board panel, but maybe didn't work before the law judge?
Well, so in this particular case, it was the claimant's own assertions on his WTC-12 that allowed us to cross-examine him in such a way to confirm that he had not only prior qualifying Article 8A work for a construction company or a recovery company, but he also did volunteer work, right? This is something that he conceded on his claim form. And so... and
he probably wants to allege that, right? Like if you're a volunteer, you probably want to make it clear to the Workers' Compensation Board all the things you did in the aftermath of 9/11, right?
Yeah, sure. I mean, people are very proud of having volunteered, and that's great. But, when your client, as in our case, is a private company, and the person did volunteer work, you always want to look and say, well, should this be with the volunteer fund? Should this more properly be with the volunteer fund? And that's what we did in this case. So if the claimant elects to pursue the claim as a volunteer, our client may not be liable for the claim. But I mean, this same philosophy, the same mode of thinking applies to any claim where the person worked for multiple employers, which is so often the case with construction or with asbestos type workers, whether it was volunteering, whether it was different employers. You always want to explore whether there's a possibility that the liability should belong with some other employer or some other insurance company.
That's a good point. Actually, the comparison to your run-of-the-mill slip and fall, where you might have multiple employers, it's the same thought process. So I guess when we look at that board panel decision, we have a rescission of findings made by the law judge, right? Why do you think those findings couldn't have been made by, I know they could have been made by the law judge, but what do you think is the reason why a law judge isn't making that the finding now? Because I could sit here and make the argument that if the law judge did the right thing at the very get-go, the claimant would be at a better place. But when the law judge makes a finding that is easily appealable, like what happened in this case, it actually creates a longer timeline and a delay that only serves, well, not only, but it does serve the employer and carrier's interest, because now there's a delay in the proceedings. So why do you think a law judge, or maybe the law judge in this case, didn't accept our argument that where the board panel did?
Right. So first of all, I agree completely that it's actually more favorable to the World Trade Center claimant to have everything done procedurally correctly right, the first time, I think some judges are maybe eager to establish a claim in favor of a claimant because they are very sympathetic claimants, and they want these people to be compensated without too much delay. But of course, having to appeal a decision takes longer than just continuing the case for example, in this case, another party to be on notice.
Right.
So, I agree with you that it would have been better to do it that way without having to appeal it. And I've kind of lost track of what was the actual question.
Well, I guess I think you touched upon it with, why a law judge might make a decision that a board panel is not going to make, right? Like one thing you said is, you have a very, what's the word? I guess, a sympathetic situation where you want to have a case established. Board panel is looking at the case more so on the facts and the law, right? They're not there taking testimony, and it's actually easier for us to create a procedural argument when the judge doesn't do it correctly. So you touched on one part of it. Is there, the follow-up question I had was, is there a, I guess an experience factor tied into it? Like, I don't know that there are enough World Trade Center cases before a small amount of judges that just know Article 8A inside and out the way that you do, that maybe they don't have like the right tools or knowledge to actually go through the process correctly, because it actually interplays with what you were saying as being maybe like, some judges being more likely to just establish the claim because of who the claimant is as opposed to what the law says. Do you think that there aren't enough World Trade Center cases actually that it would actually influence a judge in a way that they don't have enough experiences with that type of case? Because every judge sees the slip and fall. Every judge sees I hurt my knee, right? They don't see the asthma cases as often, right? The World Trade Center rescue, cleanup, recovery, exposure type cases. Is there an experience factor that prevents them from making the right decision earlier?
I think so. Having done enough of these that I can tell right off the bat, when I see a judge's name, when I know who's handling the case, I know the ones who definitely do know quite a lot about it. So I know when I'm going into a hearing with a judge who really does know what they're doing with Article 8A. And I won't name names, obviously, but sometimes you do get a judge who, my impression would be, okay, maybe they haven't done as many of these, and you kind of have to try and guide them in the right direction while advocating for your client, obviously. So that can be a little bit of a challenge, and thankfully we have the avenue of appealing when things don't go our way. But it's definitely a factor in it, although I do have a great deal of respect for all the judges of the National Workers' Compensation Board. Very, very important tagline to end it with. I think that because of all of this that's at play, right? Sometimes, from the insurance perspective or the employer's perspective, initially it's such a difficult thing to comprehend that you get a claim 21 years later. But explaining it as far as like the manifestation of disease makes a little bit more sense. And also providing employers and carriers with a little bit of a playbook about how you would investigate these types of claims makes sense. Do you think that that playbook is something that you can rely on each time? Or are there cases where maybe you veer in a different direction? You say, like, I'm not interested in talking to the employer from 21 years ago. Are there any fact patterns that maybe might present you with a reason to veer from your playbook? I mean, I think you always do your initial evaluation from that tried and true playbook, but just like with any other case, there are so many different variables, so many different fact patterns. After you've lived with the case for a little while, you kind of figure out, okay, these defenses are stronger in this case, and those defenses are stronger in that other case. So it's not always going to be the same defense that you feel is your best one, right? In one case, it's going to be, oh, this was routine work. This was not rescue, cleanup, and recovery. In another case, it's going to be, hey, this other employer should be responsible for the claim. This other carrier should be responsible for it. So within the broader playbook, I think it's pretty well established, and then it's a matter of looking closely at the facts in your particular case and figuring out what are your better arguments.
No, I think that's the right way to go about it, right? Because I think sometimes, we see some defense work done where it's like they're going through the playbook, they're going through the motions on how to do something, and providing that nuanced eye, like that experiential, modification to how these claims work and how we defend each and every single one on a more customized basis is actually what clients really need and what they deserve. Because a World Trade Center claim should definitely not go through the motions. It's very, very, very distinct and intense. There's so many fact-specific ways that I think a claim can turn out, whether it's compensable or not, and who's liable for coverage. So I think that makes sense. So that might actually be a great place to end the segment. Do you have any takeaways or tips for employers when they get this, other than your playbooks and strategies? Anything to watch out for? Any trends?
I'm not sure there are any trends at this stage,
other than that they just keep getting fired. Yeah.
Yeah. No, I mean, it really is a question of gathering as much information as you can and trying to. It's a unique area of law, even within the workers' compensation law. There are different rules, so it may require the help of an attorney, but it's unlike really any other kind of claim type that you're going to get in the New York workers' compensation law. So you really have to take a close look at all the facts to figure out, what your defense might be, or conceivably whether you might want to accept the claim. I suppose that's an option as well, although that's not our normal recommendation. But it's you really want to know as much as you can about the case.
That's great. I think that's a great way to close here. So for Tim Kane, thank you for being on the show.
My pleasure.
For Tim Kane, my name is Christian Cisan. We'll be right back with the Paralegal Minute. And we're back for the Paralegal Minute. We have two new paralegals this month, Melissa Gannon and Uma Mistry. Welcome to the show, guys.
Thank you. Happy to be here.
As you swivel in your chair, just like Dr.
You
Evil
told me
style.
to bring a chair in, so I'm bringing my swivelly chair.
Okay. So when I asked you guys if you wanted to be on the show, there was this decision point for you guys for which case you want to talk about, right? Melissa's got a couple cases we could talk about. And I was like, a couple? So where we're ending up now with this case, it almost makes me wonder, what was the runner-up?
I don't know. Did you have a runner-up case?
I don't think I had a runner-up case. This was the only case I thought of because of obvious reasons.
The only one that I had was...
Nothing compared to this fact pattern, I guess.
This fact pattern was something else, but the only one that I had was someone who was electrocuted, and it was just through one little plug and maybe a hand, but she was claiming every single body part in her body. From the toe.
Well, don't give away a future episode, Uma. No.
So maybe later on we could do that one.
Okay, so we have this one fact pattern, and to remind everybody, the Paralegal Minute showcases not only our talented paralegals, but also some of the crazy hypothetical situations that I guess they're not even hypothetical. This is real. This is a real thing that happened in a case that kind of brings life and color to what we do every day. Because, you know what, I don't know about you guys, sometimes when I tell friends and family about what I do, they think that I'm the bad guy, right? I'm representing the employer, the insurance company. It's well, you know what, here's this fact pattern for you. I'm going to lay it on you. Who's the bad guy now? So, Melissa, since it's your case, what can you do to start us off here?
I mean, it was a pretty straightforward case. When we inherited it a few months ago, guy tripped and fell, rolled his ankle, hurt his back, going through all the motions of indemnity, medical, all that stuff. I don't remember if it was an IME or a medical, but he reported that he was working again. And he wrote his employer on the intake sheet, and my attorney read it as Ralph's Deli. And I was like, okay, Ralph's Deli. So I looked at the intake sheet, and I was like, that doesn't say Ralph. So I read into it more. I was like, does that say Reptile Deli?
Oh.
There's a stark difference between Ralph and Reptile.
I mean, his handwriting was really bad. So
Okay.
it was fair that it was...
And when you hear deli, you usually have a name before it.
Yeah.
Right? So it, like Ralph.
It seemed
right?
pretty normal.
Like I'm working for Ralph's Deli.
Yeah.
Okay.
Part-time.
Putting some sandwiches together.
Yeah. No.
That's
No.
not the case.
So I looked into it to see if this was a real place. It is a real place.
Like you Googled Reptile Deli.
Yeah.
Okay.
It's a real thing. It's a bug and maggot and mouse holding thing to feed snakes and reptiles and stuff.
So it is a deli.
It is a
Just
deli.
not for
Oh.
us.
Yeah.
Wow.
Oh
Nice.
my
Nice. Nice, Uma.
So I was like, So I said to my attorney, I was like, this says Reptile Deli. And he's like, no, it doesn't. And I said, it does. Oh, no. And so I said, this is a real place. You know, let's subpoena this place and see what we get.
Awesome. And did the Reptile Deli give us information?
They did.
Okay.
They didn't ask for a HIPAA?
Nope. They called me up very nicely and were like, hi, we got your subpoena. You know, where can we send this information to? And I was
Right.
like, oh, you could send it to me. That's fine.
Yeah.
So we got the information. He was working part-time, minimum wage, you know, not making a lot of money, but he was working there. So then we started to question, because he's not receiving benefits at this point, how is he sustaining a living at this
Right.
point?
Right. Like minimum wage. How are you
Yeah.
living on that? Right. Which you can, in theory, I guess, without getting political. But
part-time, he was working about
part-time.
14
Yeah,
hours
yeah.
a week.
So without getting benefits from workers' compensation,
Mm-hmm.
you can't live on a part-time job.
Right.
So what happened next?
So then we went to our adjuster and said, can we get social media reports, you know, just to see what this
Great
guy's
idea.
doing.
Because, I mean, you work at the Reptile Deli, you're probably telling something about it.
Exactly.
Telling someone about it, yeah.
Once the social media report comes back, all this public information comes back that he's selling snakes, he's hosting podcasts, he's going to
Wait.
reptile conventions.
He has
Is he the Tiger King?
Of snakes. He's the
Of
snake
snakes.
king.
He's the
Of
snake
snakes.
king.
Oh my, that, because I mean, initially I was waiting for a moment where I could just ask that question, right? Like that was going to be my sole contribution to this segment of the podcast was, is this man the Tiger King?
Now you can see me out. I made my joke.
Oh, yeah, exactly. Bye. Of snakes. Okay, so the Snake Man is selling, he's hosting podcasts,
I guess webinars, but
webinars. Like, so he's educational.
he's educational.
Right, right.
He had a YouTube channel too or something?
He has a YouTube channel. I don't know if it's his YouTube channel, but he shows up on there.
There is a
To show
YouTube
his-
channel for the Reptile Deli.
There is.
Ooh.
Well, the Reptile Deli or the company that he started. We get into that.
Mm.
So, like, well,
The plot thickens.
I guess since now that we've let it out of the bag, I'm not going to say the company name out of respect for the privacy of the case, but the idea of a name having some kind of innuendo, and we get to trial, and what does he say?
He basically said it's not what it seems.
Like
He's creative with
it's
his
like,
names.
It's like you see like in a movie where like someone gets caught cheating on their significant other.
Mhm.
Like it's not what it seems.
This is not what it looks like.
It's not what it looks
I
like. Right. So okay, he's selling snakes, hosting a podcast. What does that mean for us?
I mean, it's not like he's selling, $2 snakes. I mean, these snakes range from $500 to, I think the most expensive was $6,000.
$6,000.
Which would
for
make
a snake.
sense if he's only working 14 hours a week.
Yeah.
Right.
And he's coming back with selling I don't know, Ralph the Snake for $1,000. Like, he's making bank off of that.
Mm-hmm.
And Ralph the Snake for $6,000 is probably not like, a tiny, garden snake in your backyard.
Does he have pythons?
Right? What? That's not going to go for $6,000, right? It's going to be a huge snake that probably goes for
Giant.
$6,000, right?
I mean, it's not more so that they're huge snakes. It's like they're nice looking snakes. Like they're pretty snakes. Like I had to go
It's not
through.
the size of the snake.
It's not
that
the.
counts.
Oh my god,
It's the quality.
that's all.
Yeah. The portion of the trial that goes about his company, right? Like he testifies about his involvement, and I guess if you're a person, whether you have any involvement with a side business, what are you going to say to a judge under oath? Do you think exactly what he did, or do you think
I could understand why he would downplay it and I think we had talked about this. You said it was a hobby. He downplayed it as a hobby,
Yeah,
correct?
he said like this is just a hobby. Like I just do this for entertainment.
And overall, he probably did have it as a hobby before, and since the business seems to be taking off, if he's selling $1,000 snakes, then he could easily just downplay it as, oh, it's just my hobby. Sometimes I make a lot of money, sometimes I don't. It's not that big a deal. Just to get the judge to be like, all right, this isn't substantial.
Trying to make it seem like it's not a steady, stable.
Right.
income.
Right.
And I think that's my point, is that the idea that the idea that anyone has a side business, no one is going to go in there and say, you know what, I'm actively involved. I do a lot of the lifting and the loading of the snakes onto the truck, the delivering of the snakes to the new owner. No one's going to say that.
Right.
So I'm reading this trial transcript, and I'm seeing, well, what else is he going to say, right? Of course he's going to say that. And I think it just lends more credence to the fact that if everybody's going to say this, then everybody should be held to this higher standard. If you have a side business, we know in the future you're going to testify to your lack of involvement in the business.
Right.
Mm-hmm.
So you have an obligation to report that business as soon as you're involved, right? Or if it's ongoing while the accident is in place, because that's the whole point of trying to figure out if you have defenses, right? If you don't disclose what you're doing, then how are we supposed to believe everything else that you say you're doing, right?
Exactly.
So where are we in the case now? Like, what are we doing?
I mean, right now we are waiting for a next hearing because the testimony was going on for so long that the judge basically said, all right, this is going on too long. Let's just continue this for another hearing. So basically we're just trying to strengthen the fact that he's making money from this business. He didn't disclose to anybody that he was making money from this business, and that it's not just a hobby. Like, this is a substantial money-making business.
Right. Because the dollar value of income received or earned is not relevant to whether fraud has been committed, but when you show that there is dollar value attributed to the fraudulent action, it makes it even more like eye-opening, right?
Do you think it will be worth getting some type of surveillance on him?
Do you
know if you've gotten any surveillance on him?
Potentially, I don't recall.
Or if he shows up in one of those YouTube videos, that's surveillance.
Well, here's the thing, right? Now that he knows that we're fighting him on this, right? Like, that's why even saying surveillance now on a recorded podcast doesn't even matter, right?
Yeah, that's
because
true.
he knows that he's in a fight now.
I mean, he's made some of his stuff private at this point, because all of the stuff that we had and we used was in public domain.
Right?
Like, it wasn't anything that you couldn't just find.
So he
on your own.
knows that we're on to him.
Yeah, actually, that's a very interesting point, because it actually shows almost like the cover up of a crime.
Yeah.
Like if you know you committed a crime, you want to cover it up. You're just instinctively doing it. Where if you felt that your side business was legitimately not fraudulent in the workers' compensation rate, you'd just be like, okay, it's public, it's out there. I'm not going to change anything.
Right.
It's almost like the post hoc action
Yeah.
adds to the material. So Uma, if you're the claimant's attorney here, what are you doing? What are you worried about? What are you scared of? Or what do you think you should be doing?
I mean, I think the claimant's attorney definitely recommended the claimant to make his social media private. And maybe, I wouldn't say maybe take a step back from the business, but make it known that I'm not doing as much with it. And if on testimony they're talking about like, oh, his lifting capabilities and stuff, the claimant will probably be like, I'm not really doing any lifting. I'm more of like the person who helps out sometimes. Like really try to downplay it even more. That's what I would do as a claimant's attorney. Just try to downplay it.
Keep the process.
And keep the process, because if he's already testifying consistently from the last hearing that he's downplaying this, that's what they probably are going to be doing in the next hearing too, if there's going to be more and more testimony.
Yeah.
The judge is just going to get so bored after this.
I mean, how do you get bored?
Yeah, I'm definitely not bored about this.
I'm not bored. I went through like 8 pages of just snakes and snakes and
Were
snakes.
they pretty? I bet they were really pretty.
They were pretty. He had a camera shy spider too, which I was
don't
very
like
grateful.
snakes at all.
On the YouTube channel that he
No,
has?
it's
or
on
just-
it was on a Facebook post of his.
Oh,
He was
okay.
listing all of the snakes and reptiles and whatever he had, and he said camera shy spider, and I was like, thank God, because I would have to
How does
clock
he know
out
it's
for
a
the day.
camera shy spider?
I
Did
don't
he ask
know.
him?
He said, would you like to be on camera? And he said, no, please, no pictures.
No pictures, please.
I feel like, yeah, that's not a file that we're going to get bored about because, I mean, how can you? This is not your run-of-the-mill, like, oh, he started off as a slip and fall, my ankle hurts, I'm not getting any benefits, whoop-de-doo.
No.
And then all of a sudden, just
Snakes
Ralph's
and
Deli becomes
Reptile deli.
Reptile Deli and a side snake business. I guess he's keeping it like level, right? He's working for a Reptile Deli and has a snake business.
He's consistent. He
Yeah.
has a career goal.
Right.
Aw.
And I respect that.
Aspirations.
Love that for him.
Right.
But I don't want to see any more pictures of snakes. But I'm sure I'm going
I'm
to have
actually
to.
kind of terrified of snakes.
I'm afraid of snakes.
I don't mind snakes, but it was like it's too many snakes. If it was spiders, different story. That
Oh,
would have
no.
been all my attorney's job.
I would not be setting foot in Reptile's Deli. I do not do bugs or snakes. No, thank you.
Yeah. It's just like you're perusing like the lunch for your $6,000 snake at home.
Mm.
Like, oh, does this mouse look good?
Uber Eats.
Uber Eats.
Uber Eats.
Pack it up. Oh, man. Okay. Well, I think that's a great case to look forward to. I'm happy you guys came on the show to talk about it. And to wrap up this segment, is there anything you would advise our clients to do based on what happened here?
I mean, if we recommend surveillance or running a social media report, there's always a reason behind it. It's not, just to do something just for like, okay, there's nothing here. Like,
Right.
there's usually a reason we're asking for.
Right. And
Yeah.
coming from, an IME intake sheet,
Mhm.
right?
Yeah.
We find that and then just perform the investigation. We can do that on our end and work as like a partnership with our clients to make sure that we get, something going. So I think that's a great takeaway. Thank you guys for being on the show. And so for Melissa Gannon and Uma Mystery, this is Christian Cison reminding you to defend from day one.